Ebusuya patapa pioto ho yedemra ana evro NDC parliamentary candidate Emma Techiman South in the Bono region Yira Christopher Bayere FRA petition challenging the victory of the New Patriotic Party candidate Yira Martin J. Mensa Kosa Oka nkonwa binom a eho asem sorry right after 2024 election na out of this nice city na Techiman South and so edie eka ho emotwe ho daare in fact nipa na also call it me check collating officer eche intimidation ne ade e ba se wonye bi ma later yes aso de no call ye EC officer ho nsem ni na kokoda dinjo asem ne mo kase on the 25th January yesterday na kasa NDC parliamentary candidate ede petition court momu ese omonka assemini bi emano na assemini mo kase court meche the Techiman High Court tena assemini so no oma dismiss this petition na or they challenge the victory of the New Patriotic Party. This is the good news about the NPP Patriotic Party. Now lawyer Gary Makono Esquire for the New Patriotic Party legal eba emrase mu a ono aneda team na ono anana tie honorable Martin J. Kosa echi a semene mo kase de call support ne de odi bibia kokosi ye
see an here to say High Court in Techiman at dismiss election petition against honorable MP for Techiman South Ayenokre me pacho
Ayenokre.
Oh, okay. Nana basis for the dismissal near day.
Oh, I was election here by after December 7th. No, I'm going to tell you here. Now there's been a series of 6 all over the place. Okay, yeah, file a mandate application. Our High Court. From the Electoral Commission, it's a Ongo quality. Now declare the one winning. Techiman South was one of the constituencies in our court. The Supreme Court. The Supreme Court, and for by was High Court judge and Tio Massam. Supreme Court can say, you go back to High Court, differently constituted. You go Tio Massam. You go Tio Massam, High Court judge for and the same order. In fact, this one in a more compelling force. Say, young quality and declare the one winning. Did not and also come home. Quality declare, just in their opinion, and in the Akatua Martin Kosa on our 1 year. Or when we know, I could swing in our parliament or any Kama. Fair Kotia, Bajara Basonte, as I file election petition or court, Techiman, or file Emremono, and I'm ready election petition. Quite technical, or your lawyer, only Sadina, or a reality. Until lawyer file man or file no, so I did what we call security for cost. It's an application now the court move as party. Now the two petitioners so the court may hear the court may determine say some of the court now. Yeah, this is how we at all. So petition here favorable petition. There's a depend on the beginning court no. Or Babuka. Sadia no. Lawyer no one yet. For petition panel. I'm more for the very honorable on WhatsApp. To the buyer, I'm sure I didn't need them say, oh, young bossy, young search to find out what I say. Lawyer, follow the papa or comply with the mandatory provisions concerning touching on this petition. The question, I say, well, yes, I did. And once I follow and all the very honorable through WhatsApp. And no cross call they didn't give me any order. So on 7 via WhatsApp, there was no order like that. On more than a pay. No, yeah, they were here. Tinina Muna Sikuvi and say, Adia Wayano, and Yambra, and she will file a petition. Let's say, one will court for skill for Costa. Petition Agasano, invalid. Invalid. And he apply court in Montumu. Because Adia also Yano, want to me and court chi motion, chi motion, no chi, they want to carry no. And then they acquire no Sidavi, Ranche, whatever, no, and swinging no, my trouble. And just stands down there, the Chima herself, I send me ago, Ira Martin Cosa, a good MP. So,
but Aban is saying, no, is the petitioner no out of time? In the event of so sign, ever prepare a new petition now or sign the qua or you're out of time, Cecilia?
We're totally out of time. So, when there's a gazette in the bar, you have 21 days within which to file your election petition. At the same time, no, you have 21 days within which to comply with security for cost. So what you say? And you said, yeah, or you're way out of time. Or you're way out of time.
And away no, on to me file motion for leave to seek extension from the court, right?
Debbie, because I say time shall not be extended.
Yes.
Time shall not be extended. And I am under the provision. And the way we are there not emphatic. Who say you are filing motion. So I started the petition. No, I'm not so squarely. No, I'm not filing. Say, court no moment security for cost. And all this comes with money. And you know, they really worried their clients, but that is not our business. Our business is that you file a petition without going through the mandatory provisions of the law to comply. The petition itself is invalid. And so the court has held so in full compliance with Section 18 of PNDC Law 284.
Very well. And lawyer, where they away from Techiman South, no, on Akwetiadi, and what's the latest, me pacho?
Oh, Akwetiadi, so there are different streams. Bakuye, petitioner pending or court war, and the one. The other one, the contempt, court no move here. Editia, Kume. Bakuye, Supreme Court, first Procedural and prohibition application. I filed it here, High Court in Teshima. Sorry. Because Teshima, oh, I court before there.
Yes.
And about second prohibition Procedural application pending on the contempt and the conviction. And the Supreme Court say, until say, you be here, now you determine the case before it now, which is Procedural and prohibition against the judge now. All proceedings in the court must stay. And the case was adjourned to the 12th of this month. So as it stands now, the London High Court judge cannot proceed to convict. Cannot proceed to sentence because the Supreme Court says, please hold your hands pending the hearing and determination of the social application and prohibition application which is before this court. Nobody can do anything. UBI is in abeyance until we go back to the Supreme Court for the Supreme Court to hear the matters which is before it. That is all.
And the statutory application is currently before the Supreme Court, right?
That is correct. Okay. 2 applications. The first one was filed when the London High Court judge made the earlier ruling saying, sir, set aside the ruling that he delivered on the interim injunction. And the second was filed when they delivered a ruling on contempt without hearing an excommunication. Without hearing the excommunication, because let's not forget that there were motions pending before the court. Our court to and which motions had a bearing on the contempt. Our court 90. The committee or Supreme Court saying, sir, the right to fair hearing has been breached by the High Court judge. The Supreme Court get to hear and determine the matter. The Supreme Court is saying, sir, until we hear this matter, everything should stay at the High Court, because you all know that hearing is fundamental. If you don't hear a man, you can't condemn him. FM. And that's why before the Supreme Court, so he was not heard. He was not heard by the High Court judge on the contempt, because there were applications pending for the High Court judge. There were a bearing on the contempt application that was before the court, which the court did not hear those applications. Because not did to be here court, no. Not did any due. That was 26th of February, and yet contempt was heard, and then he was convicted. Hence, the second certiorari and prohibition application for the Supreme Court.
Lawyer Gary Nimakon, may I not say Bibi any a best never be din comobio? Why?
And there will be not seeing him.
Yeah, that's it.
Thank you.
He is the director legal for the NPP, Lawyer Gary Nimakon, and Motesi Aneno AD and Komo. Techiman High Court had dismissed the election petition filed by the NDC parliamentary candidate Christopher Beyere, challenging the election of Honorable Martin J. Mensah Kosa as being invalid, since the petitioner failed to apply for security for cost to be determined and paid within the period prescribed by law and in line with Section 18.2 of the Representation of the People Law 1992, PNDC Law 284. In the procedure and arena. Neoma never say or you within a particular time a while in ama court no abo asemno ato edi egu, and when a procedure prescribed by law say a breach of a statute say there is no saving grace for you. In the Oshe High Court Civil Procedure Rules na yewo Order 81 no is saving mistakes be a court it me okay we dey be like typing mistake not necessarily administrative errors maybe why there is a typo. A DB and also Boshe baby, court ne etimi. By your neoma be as a breach here, the court cannot save you. But a breach of statute, in way a breach of statute, and it's not court, no, a general so abo asemno ato ego, and that's where we are.